Thank you, everybody, for coming out to this morning's webinar. We're going to be looking at the basics of fair housing enforcement, just the nuts and bolts, uh, to have a good understanding of how it works and how the process is intended to work. Short introduction. I'm Steve Tomkowiak, Executive Director of the Fair Housing Center, Metropolitan Detroit. Been in this position for almost 6.5 years. Prior to that, for 28 years, I did work on fair housing. Fair housing was my major work, wasn't secondary. And in that capacity, I've had a number of fair housing trials. I also work part-time with HUD, National Fair Housing Training Academy. And one of the courses I developed and have, worked with others in delivering has been litigation of fair housing cases. So I have a lot of experience on the enforcement side of things. And I hope that you find this helpful to you this morning, just so that you have a good understanding of enforcement and able to make effective options when that becomes necessary. So key questions are, there's about 4 of them here. What are the resources for analyzing a fair housing case if you're deciding that enforcement, or turns out that enforcement is necessary? And then where can a fair housing complaint be filed? What are the best options? And what are the time limits for filing a fair housing complaint? And what's the role of Fair Housing Center? And what services do they provide for persons that are challenging a fair housing violation or a suspected violation? Thank you again to Mishta for sponsoring this webinar. They sponsored many of our webinars. They're listed on our YouTube page, and there's materials on our website as well under services and resources. They're all listed there. Without Mishta's funding, this would not be possible. So our agenda for this morning is we're going to look at main 4 categories. First, what is the challenge when it comes to fair housing enforcement? And it is a challenge. Then what are some steps or some guidance that can be given in analyzing, doing a pre-enforcement analysis of the complaint or the potential fair housing case? And then where should someone go to report a fair housing violation or suspected violation? What forums can that be brought in, and what are the time deadlines? And there's various time deadlines. Again, if you're untimely, there won't be any claim moving forward. So you have to make sure you're meeting time requirements. And then last, I'll spend quite a bit of information. What is unique role of fair housing enforcement organizations? And they do provide a very important role. So the first thing is, I want to emphasize this even before we get into some of the enforcement specifics. The congressional intent as to the Fair Housing Act, which is Title 8 of the Civil Rights Act of 1866, strongly favors complaint resolution. And Congress went so far as to mandate that conciliation efforts be conducted during the entire period of the complaint process, from the time a complaint gets filed with HUD or a state or local agency, all the way through the time that there's been a cause determination and a charge issued, that conciliation resolution be attempted. The same thing is reflected in Title 7 of the Civil Rights Act of 1968. That deals with employment. Supreme Court in the mock mining case put it this way: Title 7, as the government acknowledges, imposes a duty on the EEOC to attempt conciliation of a discrimination charge prior to filing a lawsuit. That obligation is a key component of the statutory scheme. It's mandatory, not precatory, meaning it's not just good things or recommended. No, it's a mandatory requirement. So anything that I say today does not override the understanding that the goal is complaint resolution. That's ultimately the goal. But there are times where it's not going to be resolved and enforcement is necessary. So what's the challenge when it comes to fair housing cases? And there is a major challenge when it comes to fair housing enforcement. So let's assume that a fair housing violation has occurred. What's the next step? The challenge is this: the fair housing law is so simple, right? Someone discriminated. People can understand that. They turned me down, or I was denied housing because of my race or color or disability, any number of a protected class categories, or because there's children. And people often can recognize that there's a violation. The difficulty, the problem lies here in not in knowing whether a particular act is unlawful, but knowing what to do about that act once it has occurred. And this is a statement by Professor Robert Schwem. He's the leading professor in fair housing field. He writes this, and actually this was written to kind of a treatise, and John Roman has a discrimination practice manual for attorneys. But Schwem is writing this in a manual for attorneys. It's difficult for attorneys, let alone what lay people have to go through the labyrinth and the complexity of figuring out what to do with their cases. It is so sad. Employment, and even in cases of discrimination cases under Title VII, people lose their claims and they don't unable to effectively assert their rights because they can't get through and they don't know what to do and they miss deadlines. And it's so sad. So I want to make sure that those things aren't missed. The fortunate part, Title VIII Fair Housing Act is better, I think, than Title VII. Title VII requires that a discrimination complaint be filed with the EOC within 90 days. There is no mandatory filing requirement with fair housing. So many cases are not lost in housing, whereas they are lost for lack of timeliness in filing claims or complaints with the EEOC. Another little kind of a twist on it, when it comes to fair housing, a complaint gets filed with HUD or a state and local agency. Different terminology under Title VII. The initial complaint is called a charge when it comes to Title VII, but basically it's synonymous, but it just has different kind of a label on it. So key thing is this: you need to conduct a pre-enforcement case analysis. Is your case one that you should proceed to enforcement? So what would the steps that you would do? These are some key resources. First one, I kind of mentioned it already. Robert Schwem has Housing Discrimination Law and Litigation, the leading fair housing professor. He has chapters on each of the key fair housing issues. For example, discriminatory statements, he's got a chapter on that. On lending discrimination, there's a chapter on that. So on all the various areas, you can read through, if you read a chapter of Professor Schwem as it relates to your complaint. Like, for example, you say it's a retaliation claim. Read the chapter by Professor Schwem on retaliation. Now, I'm not saying you necessarily have to buy his, it's too expensive. It's, I don't know, a couple $1,000s. His treatise is very expensive. However, go to a library. It's worth going to a library, reading it, making a copy of the chapter that would pertain to your complaint. That homework is invaluable, not only for someone that has a case, to someone that's investigating a fair housing complaint, or an attorney. You want to read what Schwem has to say. Then the second good source are policy statements and guidance. And on the PowerPoint that I'm going to provide with the YouTube video, these links are going to work. So HUD has a part on their website which has key fair housing policy statement, guidance, and notices. However, it's very incomplete. So you're going to have to really look a bit further. But the why that's so important is often when there isn't clear case law in that, many of the courts will defer to guidance by HUD and the Department of Justice. And we'll talk a little bit more about those on the next slide. Another key source are the HUD regulations. You may notice here that I don't even put the Fair Housing Act on here, because HUD in the Fair Housing Act implementing regulations, specifically 24 CFR Part 100, really restates all the key requirements of the Fair Housing Act, but gives additional information and explanation and illustrations and so forth that are very, very important to use. If you don't look at the Fair Housing Act and you only look at HUD's regulations, 24 CFR Part 100, you won't be missing anything. 24 CFR Part 103 has to deal with the complaint processing, and 24 CFR Part 180 has to do with the administrative hearing process. Then there's court and administrative decisions. Those you can kind of almost Google search it. Another really key source, which people don't often use, is Google Scholar. can be a great source for finding current court decisions on given topics. The HUD administrative law decisions are listed. Unfortunately, it's not broken down by topic. They're just grouped according to protected class, one of the 7 protected class categories under the Fair Housing Act. So you have to scroll through 10, 15, 20 of them to read. So it's not a real easy way to research HUD administrative law decisions. But the key thing is if you've gone to the chapter in Schwem will have identified the major fair housing cases and the major HUD decisions that really will give you a pretty good guidance to use in analyzing your case. And then the last thing for attorneys, I would use Rauman's Housing Discrimination Practice Manual because it has sample briefs, discovery materials, and so forth. And that's a great source. Again, that's very costly as well, so you may want to go to a law library for that. And here's just kind of a quick illustration about these guidance materials and the regulations and so forth. For service and emotional support animals, HUD has a 2020 policy. The DOJ has guidance, FAQs, frequently asked questions about service animals, and the ADA. If it's an ADA situation, not housing, but a place public accommodation, you go to the DOJ. When it comes to housing situation, HUD's 2020 guidance. For reasonable accommodations, you want to go to the regulation, 24 CFR Part 100.204, then the joint statement on reasonable accommodations under the Fair Housing Act. There could be additional guidance. I have one listed here when it comes to local land use, zoning ordinances, and application of that in the Fair Housing Act. For reasonable modifications, we've got the HUD regulation and the joint statement. For criminal records, HUD has an Office of General Counsel guidance, April 20, 2016, great guidance on how the Fair Housing Act applies to the use of criminal records and housing decisions. And there's HUD as an implementation of it, which has further guidance with some really good stats. That's June 10, 2022. HUD did a notice of proposed rulemaking dealing with barriers and HUD assistance housing based on criminal record. That rulemaking or proposed rulemaking has been withdrawn. However, it is still a really great, helpful source to review with case citations. For sexual harassment, there's a quid pro quo and hostile environment in the Federal Register. That has a great deal of guidance as well. It's pretty lengthy, but it's enormously helpful. And there's also Q&A on question and answer on sexual harassment under the Fair Housing Act. So this gives you some idea what you want to look to in analyzing your case to decide, or your complaint to decide whether it's suitable for enforcement, or if you're assisting someone with enforcement. The next part you want to be aware of are various theories of liability. You don't need to spend a great deal of time on this, but if you need information as to what an investigator or what a judge is likely to do in analyzing your case, the real best source would be HUD memorandum on the elements of proof. That will distinguish between the various kinds of violations and what evidence is needed to establish your claim. And then you use that to see if you have evidence to establish the essential elements of your claim. On disparate impact, HUD has a guidance, the regulation 24 CFR 100.500. We call it the 2013 Disparate Impact Rule, or DI rule. HUD also came up with a disparate impact rule in 2020, which greatly restricted the ability of people to bring disparate impact claims. My gut feeling is they're going to come back with a similar rule like that in the near future. There are also court decisions in applying the fair housing case that got before the Supreme Court dealing with disparate impact, Texas Department of Community Affairs versus Inclusive Communities, and they want to look at that. Disparate impact is a complicated topic, but there's information to help you with that as well. Then there are other legal theories, for example, that don't fit in disparate treatment and disparate impact. For example, reasonable accommodation and modifications do not require proof of an intent to discriminate. The HUD memorandum will explain that. There's other ones like design and construction do not require proof of an intent to discriminate. So those are exceptions to different than disparate treatment and disparate impact, but that HUD memorandum will outline that for you. So that gives you the basics in analyzing your case. Now, if you are going to proceed to enforcement, where do you report the fair housing violations? And what are the various forms to present the fair housing cases, and what are the deadlines? Well, Here's a listing of several options that you have. There's, of course, filing a complaint with HUD, there's state and local civil rights agencies, and the U.S. Attorney General through the Department of Justice. That's a third option. Or someone can go directly into court. And the last at the bottom, and I spend quite a bit of time talking about that. What's the role of a fair housing center or fair housing enforcement organization? First of all, HUD has jurisdiction over complaints under the Fair Housing Act, and then various civil rights laws applicable to programs and activities involving federal financial assistance. Basically, federal programs and activities. They're listed here. You can see them. Most of the complaints that go before HUD are really based under the Fair Housing Act. And then if it's, for example, a municipality or something like federal funds, they'll often will include a claim like race discrimination under Title VI as well. If it's a disability type claim, then there may be a claim added under Section 504. Now, timeliness is 1 year from the last act of the discrimination. That's under the Fair Housing Act. People are not aware, for example, if it's a claim under the programs and activities for the federal financial assistance like Section 504, there is a 6-month limitation period. So you have to barely be aware of it. So do not delay. Again, 1 year from the last act of discrimination. If there's been several acts of discrimination, at least one must have occurred in the last year. If you're beyond a year, you can't rely on the fact that the housing provider may have discriminated against someone else within the last year, or 3 or 4 other people within the last year. There must have been an act of discrimination against you personally within the last year. And again, if it's Section 504, 6 months. So you could, let's say, it involves, a federal program or activity like, I don't know, HUD finance property. And you file your complaint with HUD after 9 months from when the last act of discrimination has occurred. You're not going to be able to have a Section 504 claim. You will still, however, have a Fair Housing Act claim. So what relief can you get? You get compensatory damages. They're called actual damages. There are 2 types. There's economic. Those are generally quantifiable, increased rental expenses. There could be counseling expenses because of the discrimination or harassment. Anything that could be travel expenses, moving expenses, whatever occurred as a result of discrimination. Then there's non-economic. These are not as quantifiable, obviously. And those are typically emotional distress damages. A component of that also would be damages for lost housing opportunity. I've got a webinar on damages, the most popular webinar we've done, just dealing with damages in more detail. There's also civil penalties that can be available, and there's injunctive, equitable, and public interest relief. Typically, when it comes to HUD is just, I wish, but they're not going to go forward with getting injunctive relief. It just doesn't happen for various reasons, which I won't cover here. It's just not going to happen. Same thing with state and local agencies typically don't. You've got to go through a fair housing center or a private attorney if you need injunctive relief. And then attorney fees can also be awarded. You can see the citation there. When it comes to punitive damage, jury trials, and evidence, there are no punitive damages in administrative proceeding. They cannot be recovered. There's no right to a jury trial in administrative proceeding. And when it comes to the evidence, federal rules of evidence do apply in administrative proceedings. So what is the role of state and local civil rights agencies? They have jurisdiction over complaints, but their jurisdiction is based under their state or local civil rights statutes or local ordinances. They do not have jurisdiction over federal anti-discrimination statutes dealing with programs and activities involving federal financial assistance. The timeliness for those, generally, they range between 180 days to 1 year. Similar to HUD, they will provide for compensatory monetary damages, meaning what? Out-of-pocket, quantifiable damages, as well as damages for emotional distress and lost housing opportunities. Civil penalties may also be recovered, or civil fines. Sometimes they're called civil fines. They can also provide for injunctive, equitable, and public interest relief along with attorney fees. Like HUD proceedings, punitive damages cannot be recovered if you're going forward in a state or local administrative proceeding, nor there's no right to a jury trial. Although the rules of evidence vary among state and civil rights agencies, some follow rules of evidence, most do not. And for those kinds of questions, you have to make sure you look at the state statute, local ordinance. They may tell you what the rules or procedures are for administrative hearings, or you could, again, you could look at what there could be kind of administrative rules or policies, but you can look those up and you can find what those standards are. Do not go before state and local agency without knowing the rules. Do not go before HUD without knowing those rules. So here's a key thing which many are not aware of. That's called substantial equivalence. HUD will refer the complaint to a state or local agency. Now, under the Fair Housing Act, the Fair Housing Assistance Program, we call it FAP, HUD grants substantial equivalency certification to a state or local agency if that agency enforces the law that provides substantive rights substantially equivalent to the Fair Housing Act. And when I say substantive rights, I'm talking about the law is comparable, equivalent to the Fair Housing Act, the complaint intake, processing, charging, and enforcement are substantially similar to that under the Fair Housing Act. Upon determination, HUD will make a determination that a state or local law is substantially equivalent. HUD will issue substantial equivalency certification to the state or local agency. Now, it's not a permanent grant of substantial equivalency status. It's subject to periodic review. I believe 5 years, I'm not sure. There's also a self-reporting requirement. For example, if there's a court decision or something happens at the state or local level where it's no longer substantially equivalent, the agency will then have to report that to HUD, and HUD will see what has to take place at that point. Here's why this matters. If HUD receives a complaint from a jurisdiction where there's a substantial equivalent state or local agency, and the complaint was made within the 180-day to 1 year period, HUD will refer the complaint to the state local agency for complaint intake, investigation, and enforcement. It does not return to HUD. It stays there all the way through. So don't expect that someone files a complaint with HUD and then it goes to a state agency and think, what's up with that, right? And they think like something's wrong or what happened. No, that is a standard practice. There's also funding. They will get funds, the state or local agency will get funds for doing that complaint investigation and enforcement. But that's why it also mandates HUD has certain requirements in the Fair Housing Act as to how thorough the investigation has to be, and it should be thorough. Now, HUD will not refer claims pertaining to programs, activities involving federal financial assistance, such as Title VI or Section 504. HUD will keep those claims. They're not going to be sent to the state or local agency at the state level. HUD may also decline to do any kind of referral if it's a claim involving systemic discrimination. HUD may take it at that point. That is discretionary with HUD. Similarly, at the state or local level, if they receive a complaint within the time frame anywhere from 180 days to 1 year, the agency, if they're substantially equivalent, will make the referral or notify HUD. I call it like a dual file. They'll send it over to HUD. HUD will then record the complaint at its end and assign a HUD number to the complaint. However, the complaint will continue to be processed through the complaint intake, investigation, cause, issuing a charge, enforcement. All of that will be done at the state or local level. But the important is they want the funding. Now, some things won't be dual file. For example, our state has marital status under fair housing law. Well, they can't dual file that with HUD because marital status there's no provision for a marital status as a protected class under the Fair Housing Act. But if it's something like disability, certainly they will send it over to HUD, get a HUD number, and get HUD funding in order to process and investigate the disability complaint. So you can simply ask someone at the state or local level, do we have a HUD number? If they'll tell you, yes, we have a HUD number and give you the HUD number, then you know that that they went ahead and made the complaint, sent it over to HUD and gotten a HUD number and HUD funding. So what the role of the DOJ play? There's two types of DOJ involvement. One is in pattern and practice cases, and the second is in an election case. under the pattern and practice is the Attorney General and through the Department of Justice. Hard not to think of the two as being the same, but the Department of Justice is like the attorney for the Attorney General. They file direct civil actions whenever the Attorney General has reasonable cause to believe that any person or group of persons is engaged in a pattern and practice of resistance to the full enjoyment of any rights granted under the Fair Housing Act, or any group of persons is denied rights under the Fair Housing Act, and the denial raise an issue of general importance. There's cases out there which talk about whether or not the Attorney General has established a pattern and practice. If it's just a one-time act of discrimination against a tenant, for example, that would not be a pattern and practice. But if it's something that involves multiple people that have been impacted by discriminatory practice, that would be a pattern and practice. And so that's what the challenge would be on the pattern and practice cases. So don't contact the DOJ if you have a single incident of discrimination. But if it's something more wide ranging, then the DOJ can and should be notified. In terms of timeliness, it's very flexible when it comes to the Department of Justice. For monetary claims, it's a 3-year limitation period. See 28 United States Code, Section 2415B. The 3-year period, though, is subject to a discovery rule. That time period only runs when the Attorney General reasonably could have known about the claim. So, for example, our office, I've done it several times, made a referral to the Department of Justice. The 3-year period runs from the time I send that notification over to the Department of Justice. That's when their limitation period is. When it comes to civil penalties, if the Department of Justice is a civil penalty, there's a 5-year limitation period. If the Department of Justice decides to only seek injunctive relief, there is no time limitation period. They can seek injunctive relief at any time. So that's on pattern and practice cases. There's also a thing called election cases. Now, a complaint gets filed with HUD. HUD finds cause to believe the Fair Housing Act was violated. Then HUD's Office of General Counsel will file a charge of discrimination. Then within 20 days after service of the charge, HUD, once the charge gets filed, HUD becomes a complainant, respondent stays the respondent, and then the aggrieved person who was the complainant in the complaint filed with HUD, when the charge gets issued, they're listed as an aggrieved person. Any 3 of those may elect to have the case heard in federal court. They have to make an election to have, they call it election, to have the case heard in federal court. Upon a timely election by HUD, the respondent or aggrieved person, the administrative law judge, chief administrative law judge will dismiss the complaint, the charge, and HUD will refer the matter to the Department of Justice within 30 days. The Attorney General, through the Department of Justice, shall file the complaint in federal district court on behalf of the aggrieved person. And the aggrieved person at that point can intervene as a party or have the Department of Justice kind of represent them. That's real key. You picture that. So instead of having it done either way, if it's an administrative proceeding, the Office of General Counsel will handle the case on the complainant's behalf before HUD administrative law proceeding. But if election is made, have that case heard in court, then the Department of Justice essentially becomes like the plaintiff for the person. Now, they do have in both proceedings have a right to get their own independent counsel to advocate for them. For example, HUD Attorney General, Office of General Counsel could say, I think the damages are $30,000. But if you get your own attorney, they could say, oh, it's $60,000. Or if it goes into federal district court, the key thing is this: in federal district court, there's an opportunity to get punitive damages, which you cannot get in administrative proceeding. So those are various options that people really, really need to be aware of. There's also an option for someone to file a direct court action. On a direct court action, again, the Fair Housing Act defines person very broadly to include what? Individuals, corporations, any kind of legal entity. It can even be a governmental entity. Anything falls under the definition of a person, can file a complaint directly in federal or state court. Now, key thing is what? There's no administrative prerequisites for filing an action in court. You can file in court without filing a housing discrimination complaint with HUD or a state or local agency. The timeliness, Fair Housing Act claims are subject to a 2-year limitation period. However, the 2-year limitation period is subject to tolling under the Fair Housing Act. It doesn't include the time in which an administrative complaint is pending. When is administrative complaint pending? It's pending from the time the complaint is filed with HUD or state or local, or the Fair Housing Act claim is filed with HUD until there's been a determination or a conclusion of the administrative proceeding. Now, at our state level, we're in Michigan. Michigan law has a 3-year limitation period for our state civil rights claims. It does not have a tolling provision like the Fair Housing Act, unfortunately. So if the complaint by the state or local agency, here our state agency, the processing goes on for 4 years, then the only option is to go through administrative process. You can't file in court because the 3-year limitation period would have lapsed. Different if it's with HUD. If HUD, for example, probably they won't, but let's say hypothetically, HUD took 5 years to process the complaint. Well, that 5-year period is excluded in determining the 2-year limitations period to filing in court. This is why I say make sure at the state or local level, A, you've got tolling. If not, B, make sure you have a HUD number assigned so you can take advantage of that tolling so you don't lose out on the limitation period in filing the claim in court. What kind of relief that can be obtained? Same as an administrative proceeding, compensatory damage. That can be economic, non-economic damage, and injunctive relief, also lost housing opportunity. Attorney fees are also recoverable. The key thing about filing direct court action is that punitive damages may be recovered. Most states, under their state civil rights laws, will provide for punitive damages. Our state doesn't. That's very unusual, but you can get punitive damages in court under the Fair Housing Act. And there's also a right to a jury trial in court, which you cannot get in administrative proceeding. That can be really attractive or a good option for people. So what is the role of a fair housing enforcement organization or a fair housing center? What are their roles? I'm going to go through a little bit more detail on this. So how it started all the way back in 1988. Congress established a Fair Housing Initiatives program. Prior to that, there were fair housing centers operating on a shoestring budget, mainly through contributions, but Congress established it temporary in 1988. In 1992, Congress made it permanent. And here's what they noted. And it wasn't in the Fair Housing Act. It's actually as part of the Housing and Community Development Act. Congress noted the proven efficacy of private nonprofit fair housing enforcement organizations and community-based efforts to make support for these organizations a necessary component of the fair housing enforcement system. And Congress revised and expanded that program. So fair housing centers are funded under Congress's FIP program, administered through HUD. So what does the FIP do? First, the FIP program defines a qualified fair housing enforcement organization, or QFHEO, and these are the requirements that have at least 2 years of experience in complaint intake, complaint investigation, testing, and enforcement of meritorious claims. And a fair housing enforcement organization, or FHEO, is similar to that, only it's been in only 1 year of experience. So there's 3 funding components of the FIP program: Private Enforcement Initiative, PEI, and that's what we're going to talk about here, the Education Outreach Initiative, and Fair Housing Enforcement Organizations Initiative, capacity building. But the Private Enforcement Initiative, or PEI, requires, or the funding requires, private housing organizations to investigate violations of the Fair Housing Act and substantially similar state and local laws, and commence enforcement actions to remedy the violations that are found. So this is going to address the PEI enforcement mechanism. So what is the PEI, Private Enforcement Initiative one? It's codified at 42 United States Code 3616A. So HUD contracts with private fair housing enforcement organizations to carry out testing and other investigative activities, discover and remedy discrimination in the real estate markets, and fund costs and expenses of litigation. And then the organizations will be involved in initiating enforcement actions administratively or litigation in court based on testing. Now, the program guidelines and standards are set forth in the FIP application and award policies and procedures guide. It requires that the organization seek reimbursement for the costs and program expenditures and basically remit those to HUD. Currently, there's a 15-day reporting requirement on any funds that are recovered through enforcement. And so it's real crucial, the role that they play. Here's the regulation for this activity, 24 CFR 125.103. It has to be a nonprofit, private, tax exempt, charitable organization, has to be engaged in complaint intake, investigation, testing for meritorious claims, and enforcement of those claims. And then upon receipt of the funds, will continue to do so. So what is testing? People talk a lot about testing. Here's a couple of definitions of it. But testing, HUD has a definition, and the Supreme Court in Havens Realty versus Holman have definitions of it. We see it as this. Testing is there to determine what are the actual practices taking place in the housing market, residential housing market. There are times where actually we do public accommodation testing so we can expand beyond it. The center in Ypsilanti did testing at a hotel. That's a place of public accommodation. So, but mainly we stick to overwhelmingly, right? We're dealing with residential housing testing or sales or insurance testing or mortgage lending testing. And so just to determine what are the actual conduct or policies that are taking place in the market. How important is testing? Numerous court decisions have affirmed the right to enter testing evidence in housing discrimination cases. And when it's done carefully, objectively, and accurately, it can be some of the most important components in evidence gathering process. There's two types of testing. One is complaint-based testing. The other is survey or systemic testing. The first one is complaint-based, just like it said. When a center receives a complaint by someone who claims that they have been discriminated against or suspect they've been discriminated against, testing can then be conducted to determine whether, to gather evidence as to corroborate or actually dispel the allegation or inference of discrimination. Then there's survey or systemic testing. There are times where there aren't a lot of complaints being made, but we've done a series, for example, of complaints dealing with American Sign Language requirements. We don't have a great deal of people bringing complaints for American Sign Language because often they can have limited communication skills and they're just not likely to even know that a complaint can be made with a fair housing center or even with HUD or a state or local agency. And so that needs to be done. Another example would be Fair Housing Act design and construction requirements. People typically are not going to know that a covered multifamily dwelling unit or property has not been designed and constructed in accordance with HUD and state or local design and construction requirements. So there's any number of kinds of claims where people are not bringing complaints. Well, we need to know what's taking place within the market. This is not unusual. It's not wrong. HUD requires this. We also have local grants that require this kind of testing. For example, MSHDA wants to know, is there fair housing compliance in their MSHDA properties or MSHDA finance properties? They need to know. Otherwise, there won't be, sadly, compliance. So that's a standard process. So how's testing conducted? It can be done over the phone or it can be on-site visits. It can be done through a single tester, a single person test that can be on-site or that can be over the phone. It can be two testers, match pair testing, or it can be a sandwich test. White, black, white testers in sequence. For example, if a white tester goes asking, hey, do you have a 2-bedroom unit available? Oh, yes, we have one here. Let me show it to you. And then that's at 10 o'clock. At noon, the black tester comes in and says, oh, do you have any 2-bedroom units available? No, sorry. If it just stops right there and a complaint gets filed, a housing provider say, oh, you know what? Yeah, we did have a unit available, 2-bedroom unit available at 10 o'clock, but it was rented out by noon when the black tester came. Well, the reason you do a quote unquote sandwich test is then if the white tester comes back at 2 p.m. and if the white tester is told, oh, yes, we have a 2-bedroom unit available, then that's going to say what? There were units available from 10 o'clock to 2 o'clock. and the black testers should have been offered a 2-bedroom unit, the same as the white testers. Testing is kind of designed and implemented to get at what is the best way to get accurate information about what's taking place within the real estate market. Majority of the time, complaint-based testing will actually dispel an inference of discrimination. So no one should, if they're doing the right thing from the housing provider standpoint, nobody should be afraid or concerned about testing. If they're doing the right thing, don't worry about it. It's not a concern. But for those that are not doing the right thing, yeah, then I guess you should be concerned about testing. And how broad, what is the scope of testing? It can be used in rental, sales, insurance, mortgage lending, appraisals, real accommodation, modification, and so forth. It can cover the whole spectrum of anything real estate related. Another key thing we do is we've initiated a test recording mechanism. You can see the little recording device here. There's one-party consent states versus two-party consent states. One-party consent permits recording where one party to a conversation or telephone call consents to having the conversation recording. Two-party consent requires both parties to the conversation or telephone call to consent. You can see the two-party consent states that are listed here. Michigan is a one-party consent. It does not violate federal law. Federal law permits one-party consent. So the concern is whether at the state level, it's a one-party consent or a two-party consent state. You can see here, Michigan, there's been some back and forth with it, but as Michigan currently stands, I'm not going to go through these, Michigan is a one-party consent state. So why do we think recorded tests are important? First, it's an accurate, unbiased way test reporting. Instead of a tester filling out a test report, which our test reports have always been accurate, never since 1977 to the current date, never been excluded. We started in 1977. Our testing evidence has been admitted. We would rather what? We're not here to shade it, slant it. We just want accurate tests. If anybody thinks that they're going to slant or shade a test, go somewhere else. You're done. One strike, no strike, you're out. No. We want accurate information. A successful test is an accurate test. Not like a police. Sometimes you feel like police are trying to get people. We're not trying to do that. Not at all. Recording speaks for itself when it's recorded. There's no concern about a tester's memory or recollection of the conversation. It's minimize the workload on the tester. They don't have to write up the report. And it's favored by attorneys. Cases that are based on recording evidence just moves forward. Okay, we saw the violation. It's in the recording. What can we do about it? Let's move this case toward conciliation or resolution. How admissibility, these are the factors for admissibility of recordings. You can see these here. Our recording devices are what? The tester can't play it back, can't hear the recording, can't alter the recording. It's automatically taken from the recording device and burned onto a CD, period. So there's no opportunity to make any changes. They're specially designed to do it. These are FBI grade recording devices. They can be used both on phone testing and in-person tests. They can also record messages left on voicemail. And here's an example of what it looks like, and it's contained in a case. So the test recording process, the tester records in time, date, manner of phone that they're calling. They conduct a test, they tag out, and then they return the device to the center, and it's burned onto a CD. That's it. That's how the test recording process works. Common questions. Why did you test us? We're just simply doing what Congress and our FIP grant requires us to do, or a local grant requires us to do. And we do testing. And the way, why did they get tested? Well, we put ourselves in the role of a typical home seeker, or someone looking for rental housing, or someone looking for a nursing home or assisted living facility or a rehab center, and going to the places and testing them the way someone would as a typical home seeker. Nobody is targeted. No one is out to get anybody. We're not out to drive anybody out of business. That's not the point. The point is just fair housing compliance. That's all we're interested in. If someone is in fair housing compliance, we're fine. The normal situation is if a complaint gets filed and there's back and forth. Through that process, typically the housing providers end up appreciating the work of the center, almost become partners. Hey, look at our policies and procedures. Can you assist with that? And we want to make sure we're doing the right thing. It actually becomes a positive experience, believe it or not. Once they understand what we do and what our role is. Is testing entrapment? No. All a tester does, according to the case law, is offer a favorable opportunity for a violation to occur. That's all. It's not entrapment. No one is being tricked into anything. The tester just simply inquires about housing and availability of housing, and information is given. Can it be tester be challenged because the tester is posing as a prospective tenant, following a script, didn't give correct information, meaning they weren't really a true home seeker? No, that's wrong. The court said it's what? Truly a small price to pay in order to what? Get accurate information about what's occurring. So that's not a basis for challenging the credibility of tester or testing evidence. And the bottom line, I can't emphasize this enough, testing in reality is more likely to dispel rather than support allegations in a discrimination complaint. Another question comes up: why can a fair housing organization bring an enforcement action if it did not incur a financial injury and only use grant funds? Grant funds are not a reason to deny enforcement action. In fact, we are required to seek reimbursement of grant funds to reimburse HUD and the federal government for grant expenditures. And you can see some of them here, talking about how testers should have fair housing centers should have a right to bring claims, meaning what? Congress granted that right as for centers as a key means of enforcement under the Fair Housing Act. One more FAQ: does the center only serve tenants and residents? I didn't realize what a concern this was for people. Our mission, again, is to ensure equal access to housing without discrimination, and we do assist individuals. However, it's very important to say this: we're not limited to serving tenants, residents, or home seekers. We serve the entire community. I got a question Friday from a housing provider, but they have a situation where a tenant wants 7 emotional support animal pets. And according to the housing provider, it's a 450 square foot unit. We are happy to answer that question. There was a certification. I got information on a certification from the therapist, I think maybe a psychiatrist, whatever, and provide information as to whether or not that is reasonable. We assist landlords, property management company, anybody, not only in terms of training in that, but specific questions, answers to specific questions. We are not a tenant organization. We are a fair housing organization serving the entire community. We do a lot of trainings for municipalities. City attorneys should feel free to call us. Anybody, we get calls from state legislatures. We get referrals from U.S. senators. Commonly, we serve them. They have an issue with what constituent has a housing related question. They send it to us and we act on that and we assist them. Our board consists of cross-section of community, from the lending institutions, realtors, property management companies, anybody. We serve our entire community, and because we serve our entire community, it's grant funded, it's free of charge. If someone doesn't get an answer to a fair housing question, and they're on the housing provider side, or even the tenant side, you need to contact us. Please take advantage of it. We're here to serve you. So to summarize this, what is the role of the local fair housing center? First, there's coverage for most counties in the country. Please use them and use us. We're advocacy for organizations. We do assist complaints in asserting fair housing rights. However, we do what? We also assist anybody else with fair housing questions. Certainly, we can weigh out for somebody the advantage of filing with HUD or state or local agency, or taking the complaint directly into court. We can help people with that process. We can also conduct testing. And the key thing here, there's no jurisdictional limitations on what we do. For example, we not only look for violations under the Fair Housing Act or state or local civil rights laws, we cover other laws like the Civil Rights Act of 1866 and 70, sections 1981, 1982. That has a 3-year limitation here. It varies in various parts of the country. Equal credit opportunity for lending has a 5-year limitation period. So the whole spectrum of laws. We get involved with landlord-tenant laws. I'm going to be filing a complaint by the end of the month with our state attorney general office on a violation of the State Consumer Protection Act for a tenant being charged close to $2,000 for painting fees. And she lived in a unit over 30 years. It's normal wear and tear. It's not supposed to be assessed against the tenant. And she paid it, right? That should not happen. And there were many other people that were impacted by that. But that is a core part of what we do. We don't have the strict jurisdictional limits like HUD or state or local agencies have. That is a key component of what we do. With our sub CDBG contracts, we're required to look at those things. We get involved in habitability issues. We train on landlord tenant rights and responsibilities. We do also investigate and conduct testing. Testing is a key component. That's not done. HUD does not test. State local agencies do not test. That's a key component of what we do. We also assist people in negotiating the resolution of their complaints. That's a key component so that the cases don't have to go through the ordeal and expense and angst of litigation and enforcement. Again, we do aid people in deciding where they should file that complaint. And we have, if it comes to it, we have a team of independent cooperating attorneys that can represent you on a contingency basis. I filed a complaint last week with our state agency, the Michigan Department of Civil Rights. I took that complaint and everything and sent it over to one of our independent cooperating attorneys to see if the cooperating attorney, his firm, would be interested in representing the complaint. Hopefully, it's something that he would be willing to do. And again, this would be on a contingency basis. And the bottom line is this: the fair housing centers have been instrumental in the majority of the most important, significant, groundbreaking Fair Housing Act claims. Can't say enough about that. And so it is a unique role, it's a valuable role, but it's really helped thousands, maybe tens and hundreds of thousands of people over the years. And as somebody put, it's opened up equal housing opportunities to all citizens within our country.